Special Counsel Jack Smith is hitting back hard at Donald Trump's latest attempt to delay the federal criminal case in the Southern District of Florida for Trump's willful retention of national defense information. That's before federal judge Eileen Cannon. Take a look at what Special Counsel Jack Smith writes, just calling Donald Trump out directly. Here is the government's opposition to defendant's motion for additional time to file certain motions. Jack Smith writes, the defendants move this court to indefinitely postpone their deadlines for unspecified legal motions, their fourth attempt to adjourn different pretrial deadlines or the trial itself. The objective is plain: to delay trial as long as possible. And the tactics they deploy, referring to Trump and his creepy co-defendant Waltine Nauta, as well as Carlos de Oliveira, the tactics they deploy are relentless and misleading. They will stop at nothing to stall the adjudication of the charges against them by fair and impartial jury of citizens. The court should promptly reject the defendant's motion. As part of their unceasing effort to delay this case, the defendants return to the court yet again, seeking a continuance, this time asking the court to extend for an indeterminate amount of time the deadline for filing legal motions that they have had months to prepare. Indeed, under the court's earlier scheduling order, the defendants' pretrial motions were to be filed on November 3rd of 2023. And that date was not vacated, or that deadline was not vacated until the morning of November 3rd. Unless defendants are now telling the court that they were simply ignoring the court's November 3rd deadline and were wholly unprepared to meet it, they must have been largely prepared by November 3rd to file the pretrial motions. Pause. Do you understand what Special Counsel Jack Smith is saying there? Special Counsel Jack Smith is saying this deadline was November 3rd, and they were supposed to file these motions on November 3rd. It ended up being vacated the day of, but they should have been ready to file it then. Now we're in February, and we're going to be in mid-February, and they're claiming they don't have motions ready that should have been done on November 3rd. That's what Special Counsel Jack Smith is saying there. Yet now, more than 3 months later, and after filing multiple briefs seeking to change other filing deadlines and adjourn the trial entirely, they come to the court seeking additional time to file pretrial motions. This sequence of events fully exposes the defendant's motive here: to achieve delay. Now, this is my favorite part of this motion by Special Counsel Jack Smith. Their motive is additionally revealed by the nature of one of the motions that the defendants now suggest that they intend to file: a motion to dismiss based upon purported presidential immunity, despite the fact that the criminal conduct charged in the superseding indictment took place entirely after defendant Trump left office. He now signals that he will ask the court, he's going to ask Your Honor, Judge Eileen Cannon, to dismiss the charges based upon presidential immunity. The only purpose for such a frivolous motion in this case would be to artificially create a new avenue for potential delay, this time by attempting to manufacture an opportunity for a frivolous interlocutory appeal. It is another transparent effort to stall the trial. Pause. Get what Special Counsel Jack Smith's doing right now? He's looking a few steps ahead, and he's saying, what Trump is signaling that he's going to file is a motion to dismiss the indictment on absolute presidential immunity grounds. Your Honor, this entire case involves conduct by Donald Trump once he left office. What he's claiming indefinite, perpetual, absolute presidential immunity now. So not only did we see what the D.C. Circuit Court of Appeals did, the D.C. Circuit Court of Appeals isn't binding on the district court in Florida. The 11th Circuit oversees that, and ultimately the Supreme Court resolves any circuit disputes. But in any event, we now have major persuasive authority, the D.C. Circuit, affirming Judge Tanya Chutkan's ruling in the Washington, D.C. case. At least that conduct at issue took place while Donald Trump was still in office. That's why there's at least a discussion, although the D.C. Circuit Court of Appeals, like Judge Tanya Chutkan, found that the text, structure, and history of the Constitution doesn't support king-like absolute presidential immunity from criminal conduct once somebody leaves office for conduct that occurred while they were in office. But Trump's claiming that he could order SEAL Team 6 after he leaves office to go and kill people, and he can get immunity for that. He can steal records after and get immunity for that. Heart health and staying healthy, especially when you have family, friends, or loved ones that you want to be able to spend as much time with as possible. It's so important. February is Heart Health Month in the United States, and more than half the population would still benefit from blood pressure support. Super Beats Heart Chews are the #1 doctor, pharmacist, and cardiologist recommended way to support healthy blood pressure, and they even promote heart-healthy energy without the stimulants. Paired with a healthy lifestyle, the antioxidants in Super Beats are clinically shown to be nearly 2 times more effective at promoting normal blood pressure than a healthy lifestyle alone. And with over 40,000 5-star reviews and counting, people are raving about Super Beats Heart Chews. Super Beats Heart Chews are absolutely delicious and are truly much better than any alternative supplements out there. I take my Super Beats Heart Chews each morning, and it's really helped kickstart my day. After taking my Super Beats Heart Chews, I feel like I have more energy and am ready to take on the day. Super Beats is the #1 doctor, pharmacist, and cardiologist recommended heart chew for cardiovascular health support. It's blood pressure support you can trust. Support your heart health with Super Beats Heart Chews. Get a free month's supply of Super Beats Heart Chews on all bundles and a free full-size bag of turmeric chews valued at $25 with your order by going to MeidasBeats.com. We've got our own domain name, folks. It's MeidasBeets.com. Get this exclusive offer now, only at MeidasBeats.com. And then what Special Counsel Jack Smith says, no, what Trump's trying to do here is he'll just assert absolute presidential immunity, claim it, lose, and then he'll file with the 11th Circuit Court of Appeals. And because that is you are allowed to file an interlocutory appeal, the same way Trump filed an interlocutory appeal before with the district court in Washington, D.C., when he appealed to the D.C. Circuit Court of Appeals. Remember, in D.C., in that criminal case for Trump's attempt to overthrow the results of the 2020 election, Judge Tanya Chutkan had to stay or pause that case since early December, and it's been stayed up until this time period, and we'll see what Donald Trump does if he files a petition for certiorari with the United States Supreme Court. But the interlocutory appeal to the D.C. Circuit Court of Appeals stayed the criminal proceedings there for like a 2-month period and caused a 2-month delay. So Special Counsel Jack Smith says Trump, looked at that experience and he's just going to try to claim absolute presidential immunity so then he can file an interlocutory appeal with the 11th Circuit, then have you stay the case the way Judge Tanya Chutkan stayed the case for months, and it's just Trump's way to try to build in delay. And even though, by the way, we have Judge Eileen Cannon here, who's been horrific so far, what I like about Special Counsel Jack Smith and his team here is in every case with Trump, we are proceeding with the framework of we want to bring this case to trial. I don't care if it's in front of Judge Eileen Cannon or Judge Chutkan or whoever. We're bringing this case to trial expeditiously, and we're not going to allow Donald Trump to delay. Because if you think about it, if ultimately Donald Trump filed a frivolous motion for absolute presidential immunity before Judge Eileen Cannon, and that triggers an interlocutory appeal, and then there's a 2-month delay, right now, Judge Cannon's trial is currently set for May 20th of 2024. If Judge Cannon's case gets kicked to the future, that could potentially allow for Judge Tanya Chutkan's case to fill that May spot right there, which strategically, I would prefer that rather than have Judge Cannon's case potentially go before Judge Chutkan's case, because Judge Cannon makes a mess with all of her rulings. Imagine Judge Cannon during jury selection. Imagine Judge Cannon on evidentiary rulings. Imagine what Judge Cannon's going to do before a jury. Imagine what Judge Cannon's going to, but Special Counsel Jack Smith's we're following the ends of justice. We are going to get these cases to trial, and we're not okay with Donald Trump delaying. So, to his credit, Special Counsel Jack Smith's flagging to Judge Cannon, Trump's going to try this frivolous interlocutory appeal. And I think Jack Smith's also flagging to the 11th Circuit Court of Appeals, look at what these tactics are. It's sheer delay, and that's the only thing that Donald Trump is doing, and it's so baseless. Absolute presidential immunity after you leave office? Can you get more frivolous than that concept? After you leave, you're claiming it? It's frivolous to claim it while you were in office, but after you're in office, that's just the most absurd concept ever. And then it goes on to say the rationale that defendants offer in support of their request for additional time is that the court must resolve their motion to compel before they can file substantive motions, revives a tactic the court previously rejected with respect to SEPA Section 4 litigation. The rationale fares no better here. This court should deny defendants' latest motion for additional time. Special Counsel Jack Smith then goes through the background and then talks again. Very, very strong language here by Special Counsel Jack Smith, again saying as the pretext for their motion, defendants invoke a footnote in the court's recent scheduling order, but the court's footnote clearly and explicitly rejects potential motions in limine, not the type of Rule 12 motions like substantive motions to dismiss that Donald Trump wants to file here. And then again, the language that Donald Trump's trying to file it, the argument goes, the present motion is the latest in a line of defense requests for extensions and continuances, all aimed at delaying the trial in this case, the transparent goal of the defendants from the start. This request for an indefinite extension for pretrial motions is entirely unwanted and should be rejected. And then Jack Smith goes over it in a little more detail and says, granting any additional time for motions at this stage of the proceedings would serve as an invitation to the defendants to ignore the court's deadlines in the future. For the foregoing reasons, the court should deny the motion to adjourn the deadline for pretrial motion. So, strong motion. It's before Judge Eileen Cannon, though. Who knows what she's going to do. But I give Special Counsel Jack Smith credit for the framework of we're bringing these cases to trial. You want to delay it? You put yourself on the record. We ain't delaying anything right here. Let's go. Let's go. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 3 million subscribers. We were at 2. We're on our way to 3. Have a good one. Hit subscribe. It's free.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.